As we'll call, this is basically a self-defense case, and at the post-conviction relief hearing, we contended that trial counsel should have called a use of force expert at trial, and because of that, he was ineffective in his performance. The post-conviction court indicated that the use of force expert could not be admitted as an expert, I believe, because he made conclusory findings that invaded the province of the jury and led to the ultimate issue. And our problem with that contention, Judge, is that I could more or less grant everything the post-conviction court said with respect to, he shouldn't say that Mr. Potts' actions are reasonable. And it still wouldn't refute or any way get in the way of the substance of the expert witnesses, Melvin Brown's report and opinion, which is that the alleged victim in this case was very dangerous with his specialized military training and his prior threats made against my client about wanting to kill him, as well as his abuse towards the girlfriend that I guess they were involved in an affair with in this case.
So aren't those issues that the jury has to consider?
Yes.
In determining if self-defense, applies in a case? So how is it that an expert, you think, can weigh in on that issue without invading the province of the jury?
Because he's there, and the reason we even called him in the first place is because he's there to give detail on how dangerous this person is. The jury's not going to know anything about how dangerous someone with certain specialized military training is, or what Mr. Brown was going to testify about, how someone is going to react.
But if that came out, like as far as his specialized military training, that could all easily come out on, I guess, if he doesn't testify.
Right, and he did testify about it, but that's not...
He testified, but that was not all covered in cross-examination as far as his extensive
That was
training?
brought up, but I would submit that a layman's not going to know what exactly that means. They hear the term specialized military training and say, okay.
Well, I know, but they could delve into what that means. I mean, I've been a trial judge in an area where Fort Campbell is a big part of that. We heard a lot of testimony about specialized military training.
Right.
And people can easily be examined and cross-examined on not just specialized military training, but what that means. What are those specifics? What does that training entail? How, that kind of thing. So I'm a little confused as to how an expert could and should even be able to weigh in on that.
Would Your Honor agree with me that specialized military training, that is a field that would involve some kind of technical knowledge?
Maybe, maybe not.
That's what the trial
some of them are just combat.
Yes.
That's not necessarily technical.
That's what the trial judge, she indicated that. In her opinion, it seemed like Mr. Brown was he could be an expert in some ways. It just seems like they were going to the ultimate issue. I agree, Your Honor, that they could have cross-examined I believe the alleged victim about his past with respect to the specialized military training. But Mr. Brown's point and his purpose is that he's trained specifically to evaluate danger with respect to an individual, and he went through he even described the whole process by which he does this. And so
has he ever been qualified as an expert in this state?
Yes, he mentioned at trial that he had a trial with, I believe Rich McGee hired him down in Williamson County a little bit prior to that hearing in Franklin, where he was qualified as a use of force expert. And so I think it's not so much that he's just going to get up there and, say, give opinion on the ultimate issue, but that he's specifically trained on evaluating how dangerous somebody is and how one is going to act in a particular situation. And that's the real merit and value. And so I would submit that what Judge Smith could have done, respectfully to her, is she could have said, okay, I'm not going to let him talk about whether it's reasonable or not. I'm not going to let him talk about these things which I believe invade the province of the jury. But this part of support where he does get into how dangerous someone is and how how dangerous someone with this kind of training is and how someone might react to this scenario, I am going to let him discuss that. In other words, I believe that Judge Smith, respectfully to her, she threw the baby out in the bathwater. She said one part is bad and focused on that.
How does an expert get the information from a victim? How does a defense expert get the information from the victim about how specifically they are trained and what kind of specialized training they have?
Mr. Brown read the trial transcript and saw, I believe, that Mr. Thompson was, I'd have to go back to the record and refer specifically, but I think y'all even mentioned in your summary. He basically took that and used his own prior military training and knowledge to divine, okay, that involves this, that, and that. And so based on that, this fellow is much more equipped than Mr. Potts, in that he could potentially, even if he didn't have a gun, he could disarm him, because this is the training this kind of person would have had. So he's basing on his prior knowledge and experience with both military and, I guess, law enforcement.
I'm just curious about this type of expert. So.
Right. And so he has a lot of experience, and he knows a bit about the alleged victim's profession. And so that's how he made the evaluation that, hey, he's this dangerous, as well as this is how someone like Mr. Potts is going to be reacting to the situation, because Mr. Brown said he's actually been in this kind of scenario. Exact scenario described that Mr. Potts was in with Mr. Thompson. And so that's the real meat and function of what he could present. And again, trial court, they could just cut out the parts they don't like. I mean, I had a case in front of y'all. I think I briefed it because I already foresaw the outcome. I knew it was going to happen. But basically, I was challenging Judge Dozier's decision out here in Nashville, decision to remove parts of the defense expert's testimony. Trial judges can do that, and I guess rightfully, as y'all affirmed that case, rightfully he rightfully took out parts that would be invade the province of jury and just violate the rules of evidence, while still keeping the parts that are valuable to the trial. And I don't think a jury is going to be equipped to know just the specialized knowledge that Mr. Brown presented here. And so, as far as trial counsel's failure to call him, I think we easily clear both prongs here. There's no way you can argue this is bad strategy here, because, this is an issue of strategy here, because their whole theory of the case was self-defense. They have absolutely nothing to lose from calling a use of force expert here. And given that that's the whole case, given it's whether or not, it's not in dispute that the alleged victim here was violent, that he had threatened Mr. Potts in the past, or that he had this specialized military training that made him very dangerous, or that Mr. Potts had already tried calling the police days before and during that incident. That's not in dispute. The whole thing is, was his actions reasonable or not? And so I think we easily clear both prongs. And I don't think they can really even rebut what I'm saying here, because they're going to have to go back to what the trial Judge Smith said. And as I told you, I could grant what she said, and it still wouldn't refute the substance of his report. And I know I raised the issue of challenging the Post-Conviction Procedure Act with respect to clear and convincing anyway. And as I acknowledged in my brief, that's something y'all are bound to, because the Tennessee Supreme Court's already ruled on Dellinger. But I would just note for the record that if you read Judge Smith's opinion in this, she doesn't even go through the Dellinger analysis. She just cites clear and convincing evidence. I don't knock her for this, because I see a lot of orders, and they all do the same thing. They just cite clear and convincing evidence, not this Dellinger standard that tries to say you got to apply clear and convincing to the factual claim and preponderance of the evidence to the legal claim. It's a very confusing standard. It's messed up, and I think it definitely needs to be revisited. So even if y'all denied me, I would at the very least ask that you acknowledge that, so I can perhaps present this to our friends in the Supreme Court. And if there are any no other questions, I will sit down.
All right, thank you.
Thank you, Your Honor.
General Ball?
Good morning. May it please the court. Ben Ball, once again on behalf of the state. And I'm very aware that the old adage about familiarity is not that it breeds affection. And In addition to me, I think the arguments I'll be making today will probably be fairly familiar if your clerks watching this on YouTube have some sort of bingo game going on. I think that there'll be squares here that will firmly fit, especially I imagine there's one that says something along the lines of the Assistant Attorney General respectfully and gently reminds the court that the Tennessee Supreme Court is supreme both in name and in fact. That is my response to the argument about Dellinger. The Supreme Court has decided Dellinger, and this court need not dwell on that issue. Addressing the ineffective assistance of counsel claim raised here, I would submit to this court that the petitioner has slightly shifted his argument here on appeal from the one he made in the post-conviction court. The petitioner was arguing that counsel was ineffective for not bringing this expert on use of force self-defense to testify to the ultimate question for the jury. Wasn't seeking to have this report to simply say that the victim was a well-trained former military. I don't know that that would have been very hard to get in. Your honors have pointed out ways that could have been brought out. But that's not the focus of this report. The report definitely talks about his training, but it goes a step farther. It talks about the reasonableness of the use of force here. It invades the province of the jury. Also, Judge Smith here found that the methodology in evaluating that was wrong, because this expert was cross-examined extensively about self-defense, and that is what he was testifying to. And his background was mostly on training police in when police force is reasonable. We're talking about a different standard here. He was unable to correctly state the standard that would be employed here. So even if he could invade the province of the jury here and testify as to the ultimate fact, he was not an expert who had established that he was capable of doing that. So this was certainly not error for the post-conviction court to determine that counsel was not deficient in trying to present an expert whose testimony would not have been admitted in full. And the argument was not that, oh, you can admit some of this, that you can tell about this guy's, the victim's training in the military. And I don't think there's any suggestion that the victim was some sort of highly trained special forces operator where this would need a lot. I think this could have been taken care of in cross-examination. What training did you receive? Or through simple investigation into what his role in the military was and what the standard training for that was. What the petitioner wanted was testimony about the ultimate fact. And even if this had been deficient, and it very much was not, I think this court needs to be very aware of the underlying facts here and the unlikeliness of the jury to ever return to find self-defense here. To be clear, the defendant here laid in wait for the victim in an elevated position with cover.
Yeah, was there any evidence in the record that there were threats or anything of that nature before?
There was bad blood between these two, but there was no immediate threat. What's clear in the record is that the victim's not aware the defendant is necessarily in the home at the time when he enters the home, but the defendant is very aware the victim is going to enter the home. And he is on a second floor landing behind the stair rail, essentially firing down on an unarmed victim. It's an ambush. It's not self-defense. And regardless of what this so-called expert would have testified to, it would have made no difference in the mind of the jury. So he certainly can't show prejudice here. So the post-conviction court got this one right. And if this court has no further questions, I would ask this court to affirm the judgment of that court.
All right, thank you, Jim.
Thank you, Your Honors.
Mr. Murphy, your rebuttal?
Yes, Your Honor, briefly in response. So my colleague on the other side, he indicates to us that this expert would not have been reliable because, he was trained as law enforcement and there are different standards for law enforcement, but this was clarified in the record. He made it pretty clear that the standards for defense are only different with respect to effectuating an arrest. Outside of that, they're 100% the same, and you don't need to take my word for it. I cited the actual statute in my brief. It's right there and clear. This isn't a case of effectuating an arrest case. This is a case of simply, was Mr. Potts' actions reasonable or not? And, he indicates that, my client was lying there in wait, but that kind of diminishes the full context of this. His girlfriend, Miss Burnett, contacted my client saying that Mr. Thompson is headed there, and he needs to get out of there. And Mr. Potts already tried to call 911. They didn't do nothing the previous day. Tried to call him right before moving it. During this very encounter, gunshots can be heard on the recording call. And, you know, it's unfortunate. It's something Mr. Potts wishes had never happened, but it happened. And as far as whether a jury would have found whether or not it's self-defense or not, I think that's for a jury to call. And Mr. Brown certainly would have given the jury informed information on this, given all what's known in the record. And that's all we're asking, is that a jury be able to fairly consider evidence here with the inclusion of Mr. Brown, not get into all this other stuff, and make a decision. Lastly, I think there was an argument made about shifting the argument. Let's be clear here. I said even if I grant the trial court's reasoning, it still leads a logical conclusion, because I could still take part of what Mr. Brown says out and still come to the conclusion, yeah, this is a valid expert. I'm making the case. I'd say just granting. Putting that aside, I would say that everything he said is good. Y'all should accept that. And if there are no other questions, I thank you all for your time.
Murphy, thank you.
Thank you.
No ball, good arguments. Get this out soon. All right, thank you. That completes the January docket for this panel, so we'll be adjourned.